Congress.
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 Congress shall make no law.
Make no law respecting an establishment
of religion.
Or prohibiting the
free exercise thereof.
Or abridging the freedom
The freedom of speech, or the press, or the right.
or the right of the people peaceably
Peaceably assemble.
and to petition the government.
A redress of grievances.
Hello, my name is Dr. Kevin Johnson, and I'm here today with Dr. Craig Smith. We are going to discuss some of the major First Amendment cases that the United States Supreme Court has decided during Chief Justice Roberts' tenure. The Roberts Court has marked an important era for First Amendment jurisprudence in America. Cases that will impact the United States for many years to come concerning the First Amendment rights of students in schools, challenges to the right of public protests, the way electoral campaigns are financed, the authority of the FCC, the exposure of children to graphic depictions of violence, and several more. So today we'll talk about some of the significant cases and discuss some of the concerns raised during the Roberts Court thus far. So let me begin with a discussion of student free speech rights. But before I do so, I'd like to thank Dr. Smith for being here today. So, Tinker versus Des Moines said that students don't shed their constitutional rights at the schoolhouse gate. Is Tinker going away?
I think the justices are trimming back over time on that ruling. There were several problems with the ruling. First, here's what happened. I mean, Tinker comes to school with one of his siblings, and they're wearing dark armbands to protest the war in Vietnam. They didn't say anything. So the first question is that armband symbolic speech, and is symbolic speech protected as opposed to oral speech, where we actually hear someone talking? So the first issue for the court was, do we protect symbolic speech? Well, it was during the Vietnam War. They decided they would protect symbolic speech. This was in a high school setting, and therefore they said that students don't lose their rights at the schoolhouse door. Ever since that decision, they've been trimming back a little bit. One of the main decisions was Frazier versus Bothell. Frazier was a student who gave a speech of nomination for another speech in an associated student body election. He filled the speech with all kinds of sexual innuendo. He was suspended. The court upheld that. And then there have been several cases since then, Hazelwood and several others, that have trimmed back student rights.
And so in Chief Justice Roberts' tenure, one of the major significant cases was Morse versus Frederick, otherwise known as the Bong Hits for Jesus case. And it involves a student, Frederick, who comes to school late at an Olympic torch relay event, and the school allows the students to attend this and dismisses class a little bit early that day. And so it's still technically a school activity. And the student comes and has a banner to draw attention that says Bong Hits for Jesus, which is unfurled during the Olympic torch relay. The principal Morse then says, you got to put that banner away, in which he says no, and he gets expelled for it. So then he sues, saying that it's his First Amendment rights, and the Supreme Court held?
The Supreme Court held in favor of the school, just as they did in Frazier, and they used some of the grounding that they used in Frazier, and that is that this was disruptive behavior, and that school officials have the right to control disruptive behavior. However, the dissenters were a little upset because it's not clear what the banner meant, for one thing. I'm not sure myself what Bong Hits for Jesus means. And in what way was it disruptive? Why can't a student hold up a sign when they're out on a street? So instead of students retaining their rights inside the schoolhouse door, this says you don't have your rights even when you're outside the schoolhouse door, as long as you're on, an excursion that the school is sponsoring.
And more important, there's even a discrepancy in whether or not the student was attending the school function, because the student hadn't checked into school that morning, showed up to school late. To say that he showed up to school because he was on the other side of the street, was he just a teenager that was out on the sidewalk that was showing their speech, or was that teenager then checked into school under the authority of the administrator, right?
Well, yeah, but then you have the whole issue of circumvention. If I want to circumvent the school rules, all I have to do is not sign in that day, and then I can be disruptive. So I don't think the court bought that argument.
Okay, and then one of the key parts of this case is that it's a 5-4 decision, but I think that as per our previous conversation, it shows a little bit of the subtle nuances in these decisions. So do you want to start by talking about the majority opinion?
Well, the majority, I think, comes down on the side, one thing that would be interesting is if these were college cases instead of school cases. I think that, people give more control to those who can't vote. I think Justice Thomas even has argued in some cases that children do not have First Amendment rights because they're not citizens, and therefore the First Amendment doesn't extend to them. But the majority cobbled together by Roberts was that these people have a right to make sure that disruptive behavior is controlled in the schools because it interferes with learning. I think this is a very close case because it was outside the classroom. It wasn't even on the school grounds.
Well, and showing how the ideology is very, it's not necessarily as ideological as it would appear. Justice Kennedy, in his concurring opinion, was very clear to say that this is basically being ruled for him because it was an anti-drug message that conflicted with the school's educational purpose, while at the same time, what he did, he says that this should not be licensed for local school administrators to be able to find anything that's disruptive based on their subjective judgment to be able to intrude on the First Amendment rights. And so it was a Hamiltonian skepticism of this local authority that was underwriting a lot of this opinion from Justice Kennedy.
Yeah, I think that's true, and I think Justice Kennedy was also leaning toward the kind of thing that he wants to protect speech where he can because he thinks people need to hear these arguments. They're part of the free marketplace of ideas, and so you need a strong rationale to close down that marketplace of ideas. But it's a very close case, and 5-4, as you made clear, is hardly strong precedent.
Well, and with the marketplace of ideas, we then extend to another school case, which is Christian Legal Society versus Martinez, which was basically a question of whether or not a campus club as a legal society could be denied their registered student organization status from the College of Hastings Law School. And Justice Kennedy in that case decided to say, no, if you are requiring students to sign a statement of faith saying that you condemn homosexuality and you have to repent if you're engaging in homosexual acts, then that's not a constitutional right you have because it violates the non-discrimination policy of the school. And so in this case, we see that there's a marketplace of ideas being upheld in a different way. Is that right?
Oh yeah, I think that's absolutely true. But the problem with that case is that it's looking at the 14th Amendment kind of trumping the First Amendment, and I would have preferred a little stronger rationale for that being the case. One of the parts of the First Amendment that people forget all the time is the part that says that we can assemble peaceably, and that has been extended to mean that we have the right to privacy when we assemble. We can assemble in secret, as the founders did during the Revolution, and also that we can choose who's in our club and who isn't in our club. There was an earlier case, the Hurley case, of people marching in Boston on St. Patrick's Day, and gay and lesbian groups wanted to join that parade, and the court said, no, you can't, you have a different message, and furthermore, we get to choose who's in our clubs. What they're saying here is, if you're on a campus, you don't get to choose who's in your club if it's a discriminatory policy that decides who's in and who's out of the clubs.
So this would be balancing in the structural modality the assembly clause versus a free speech right.
Yeah, very definitely, and I think that again, it's a very difficult case because of the campus involvement. Recently, there are other rulings that are saying you can't suppose that you have a Catholic club on the campus, and one of your requirements is that the president of that club be a Catholic. That's discriminatory, and some courts are ruling that you can't do that. Well, that's a little problematic, that the president of a Catholic club could be someone other than a Catholic.
So let's talk about a different issue, change gears a little bit. Snyder versus Phelps. You want to talk about this case?
Yeah, Snyder v. Phelps is a very interesting case. Mr. Snyder had a son who was killed in Iraq. At the funeral of his son, there were protests across the street by Reverend Phelps, who heads the Westboro Baptist Church. They had gotten a permit to be on that street. Another kind of technicality of this case is Maryland does not have a law that, at the time, did not have a law that prohibits people from demonstrating at funerals and around cemeteries. Other states, 23 to 26 of them at the time, did have such laws. Another complication of the case is on his way into the cemetery, Mr. Snyder couldn't see the signs of the demonstrators because they were blocked by a motorcycle group that supports veterans from foreign wars. He went in, his son was buried, he came out, it was the only funeral at that time, and later on the evening news saw what these signs said, and they were highly defamatory. They made sexual allusions about his son, which were incorrect. They attacked the Catholic Church. So this case, Mr. Snyder, after he saw the evening news, claimed emotional distress and filed a tort in the state of Maryland, which has very strict laws about emotional distress. At the initial level, he won a $10 million judgment. At the second level, he won, it was cut to $5 million, but he was sustained by the district court. Phelps appealed to the U.S. Court of Appeals, and the U.S. Court of Appeals said that the First Amendment protected Phelps' right to demonstrate even at the funeral of this young man. That got appealed to the Supreme Court, and the Supreme Court ruled 8-1 in favor of the Reverend Phelps' First Amendment rights. The lone dissent was Justice Alito, who took a different position, which we can get into.
Yeah, well, what was Justice Alito's decision and rationale in this case?
First of all, that if you're burying your son, you have an extension of your right to privacy. We have often extended the right to privacy from your house to other venues. You can walk to an abortion clinic and people have to keep away from you. Your right to privacy is there. Alito believed that the person being buried had certain privacy rights, and so did the family. Secondly, because they were burying their son and they had no choice but to bury their son there, they were a captive audience. And very often the Supreme Court has hedged back a bit on First Amendment rights when you have a captive audience. You can't say anything you want to one of your students in the classroom because they're a captive audience. So that was another reason. And then Alito saw that the standard for emotional distress was so high, and that Mr. Snyder had met that standard in court, that defamatory speech is private and therefore not public speech and therefore not protected by the First Amendment.
Well, and it has to do with the way that you see the case, because Justice Alito, if I understand, looked at the websites and the press releases to give meaning to the protest as it occurred, right?
Right. Context, in my opinion, context creates meaning. And when you put their protest on that street corner into the context of their press release, which named Matthew Snyder, when you put it into the context of their website, which named the parents and Snyder, it is personal speech directed right at them.
And context is really important to discuss, and we'll talk about that when we return, as well as Chief Justice Roberts' majority opinion in the case.
The Center for First Amendment Studies conducts research on freedom of expression, religion, and assembly. Visit our website at www.firstamendmentstudies.org, where you'll find research papers and 2 e-books titled The First Amendment and the Media, as well as The First Amendment and Religion. The Center has also been proud to sponsor several major books by its director, Dr. Craig R. Smith, today's featured guest. The most recent include A First Amendment Profile of the Supreme Court, published by John Cabot University Press, and Silencing the Opposition, How the Federal Government Suppresses Freedom of Expression, published by the State University of New York Press. And finally, The 4 Freedoms of the First Amendment, published by Waveland Press. Each book is available at Amazon.com or the publisher.
Hi, I'm Kevin Johnson, and I'm here with Dr. Craig Smith, and we're talking about context in Snyder versus Phelps. as you were saying, about context in this matter?
Well, the context, when you read the demonstrators into the context of their website and what it said, attacking the family, and their news release and what it said, attacking the family, that becomes private speech. It's defamatory and subject to emotional distress rules. When they demonstrate at Annapolis, the capital of the state of Maryland, the same day, that has no context that makes that speech private. That's public and that's protectable. And when they went in front of the Naval Academy, same thing. But when they come to a funeral and they name this poor kid and his parents, I think it's actionable.
Well, and in the context of Snyder versus Phelps, you've got Chief Justice Roberts writing that this doesn't prevent future restrictions on protesters at military funerals. In fact, if there was a piece of legislation that abided by the time, place, manner restrictions and was content neutral in terms of its application, it would be permissible, right?
Yeah, and Maryland did pass such a law. It's just that this family was damaged and they weren't able to make themselves whole with the damages I believe and Justice Alito believed they should have received. We tried to pass such a law in California. It does not have such a law. And the governor misunderstood the ruling from Snyder v. Phelps and vetoed the legislation, which would have protected cemeteries from demonstrations. So it continues to be difficult. Also, in Roberts' majority, over and over again, he talks about the anguish this family went through. And I think a close analysis of Roberts' opinion, just using his evidence, makes it fall of its own weight. I think it's a very weak decision.
Okay, let's switch gears here to arguably the most important decision that has to do with the First Amendment in the Roberts era, Citizens United. You want to talk a little bit about this?
Yeah, Citizens United is an interesting case. Citizens United was an advocacy group. They made a documentary about Hillary Clinton that they were trying to sell to cable channels. The Federal Elections Commission intervened and argued that this was persuasive speech in a campaign funded by a corporation and therefore was precluded by the Campaign Reform Act and did not allow the cable companies to show this particular documentary. Citizens United appealed all the way to the Supreme Court, and the Supreme Court overturned lots of precedents all the way back to 1906 when the first prohibitions on corporate contributions were set in place under the Theodore Roosevelt, and said no, corporate entities have First Amendment rights and the public has a right to hear from them. Unions, the same way. They struck down, therefore, that part of campaign reform. And so now unions and corporations can independently put as much money into campaigns as they want. And in 2010, we saw the results of that, heavy spending in various campaigns across the country.
And so what are the current implications from Citizens United in the context of the 2012 presidential election?
Well, you're going to see tons of money poured in. Already, they're talking about $212 million just for the Democratic convention. The Republican convention will easily match that. You have all of these so-called independent super PACs pouring money into the primary campaigns behind various candidates. Each candidate, if you don't have a super PAC, don't even enter the primaries. And so you can't coordinate with that super PAC, but you can have former staff on that super PAC that knows what you want and how you want the money spent. So I think we have a case of unions and corporations having a great deal of influence now in the election process, having more money even than the candidates themselves. And I'm not sure that's very healthy.
Well, is the implication then that one wealthy super PAC can actually keep you in a race when you may not have as much support as would happen in traditional politics? You'd fall by the wayside, but now you're kept in the race, right?
Yeah, in many ways that's happened, and that's one of several factors as to why the Republican primaries went on for so long. You had these super PACs behind the major candidates and could continue to sustain them. You also had one man giving $10 million hits to one candidate through the super PAC to keep that candidate in the race. So it in some sense. On the other hand, the question is whether you consider labor unions and whether you consider corporations to be persons. They are not in the 14th Amendment. The 14th Amendment clearly says persons. It doesn't say entities. So there's another place where the Supreme Court may have fudged things. But again, Justice Kennedy gets around that by saying, I want everybody to be able to hear these arguments. I want to keep the marketplace open, and barring some compelling government interest, I'm not going to close down corporations and unions from speaking.
Well, and furthermore, Justice Kennedy's point was that the differentiation between a corporation and the press is a fine line as well, because there are news corporations now, right?
Absolutely, absolutely.
Okay, and then another point of discrepancy is about the realm of the foreign interests that are involved in the election. So you have President Obama talking about the implication of this decision, meaning that it opens it up to foreign interests, and then you have Alito giving his little famous smirk at the State of the Union address. So what is your take on the implications for foreign interests in the elections?
Well, the way the laws read is that a foreign corporation cannot participate in our elections, but if they have a U.S. subsidiary, that U.S. subsidiary can participate. So all you have to do is open up a U.S. subsidiary, and then you can pour the money through that subsidiary. The reason the law was written was that foreign interests had got involved in the Gore campaign, and the Gore campaign had to return money to those foreign interests when it was discovered. It was laundered through certain people, some of whom have gone to jail, and so they tried to clean that up. But in a global economy, it's very difficult to differentiate the company from its owner. Viacom is owned mainly by French interests, but they own CBS, they own MTV, they own VH1, and so each of those subsidiaries could have an independent super PAC that participated in the election.
So the counter to that is to say that if this decision were not upheld, then you would have individual American citizens contributing to campaigns, which would then prevent these foreign interests from being in our elections.
That's true, but the other problem is the initial decision on campaign reform, Buckley versus Valeo, that came after Watergate, that said the money I give you as a candidate is controllable, but the money you spend is not. So you can put restrictions on how much money I give you, but the government cannot put restrictions on how much you spend. I would take the restriction off of the individual citizen. As long as there's full disclosure and you know where the money is coming from, and I can make an ad against you because of who you take the money from, then I think we're in good shape. But as long as the citizens are constrained and the corporations aren't, we have a terrible imbalance on the books right now.
Is there also an implication for political messages within 30 days of an election? How does this factor into the Citizens United case?
Yeah, there has been a rule that you cannot have these advertisements 30 days before primary election, 60 days before a general, and that pretty much is out the window now because that's a restriction on a First Amendment freedom.
Okay, let's switch gears a little bit and talk about Brown versus Entertainment Merchants Association, which is based on California's law that would restrict the sale of violent video games to minors. Essentially what this legislation did was that it took the Miller test, the three-pronged standard for obscene material, and said that it should apply to violent material. The majority opinion basically was written by Justice Scalia, talked about there being no difference between violent video games and, say, Lord of the Flies as a violent novel. Do you agree with this assessment?
I do. The problem, and it goes back earlier, the person I think that wrote the most intelligent decision on this was, at the appeals level, was Judge Posner in a similar case. It came out of Indianapolis. And Indianapolis took the games that people could play in video arcades and so on and so forth that had dismemberment and things like that. They clearly defined what they meant to be obscene. They ran it through the Miller test, just like the California law. And Posner struck it down on the grounds that you cannot conflate indecency, obscenity, and violence, that they're different things. And we don't have very strong evidence as to violence resulting in aggressive behavior. Very often, if you watch violence, it's cathartic. You let out those feelings, and you're less dangerous. And Posner, of course, compared it famously to Hamlet, where you have 7 dead bodies on the stage at the end. Are you not going to let people watch Hamlet? You're not going to watch Richard III, where he's stabbed to death at the end. You're not going to watch King Lear, where eyes are gouged out of people. So that becomes, violence is a different thing than obscenity.
And so this case shows a little bit of the differences between Justice Thomas and Justice Scalia and Justice Breyer. Justice Thomas is talking about the ability for parents to have the exclusive control over what their children can and can't buy in terms of video games. Justice Scalia then differs, saying that the framers were okay with this type of violent depiction and having access to minors. Then you have Justice Breyer, who's very different from both of those in a dissenting opinion, talking about how it's not okay for us to be able to allow children to buy this material when we allow something like, when we also restrict something like a nude picture of a woman, right?
Right, but I mean, there is a distinction between video and writing, between graphics and writing, and that goes back all the way to Thomas Jefferson. I mean, Thomas Jefferson said, "I hope we never censor writing." The original Hicklin case out of England on obscenity was about graphic stuff, not written novels. That came later when they tried to expand it to apply it to novels.
So are you saying that Justice Scalia may be misinterpreting the framers here in this?
I think there's that possibility. I think there's that possibility that there was a difference between what's graphic and what's written.
And there may be also a difference between the types of words that one uses, as we see in the famous case that's been before the Supreme Court in Roberts' tenure, is the FCC versus Fox television stations. It has to do with the fleeting expletives, and Bono gets up on stage and says that this is really, really fucking brilliant, really, really great, and all of a sudden everything goes into a downward spiral and ends up in legislative acts, and it's before the Congress. What is your take on this particular issue?
It's particularly difficult because you don't know where to assign responsibility. Bono's within his free speech rights. So do you go after CBS or Fox or NBC because they allowed it to go on the air? Now, since then, of course, they put in a 5-second delay and they bleep things. But it's very difficult to figure out where to plug this in. Furthermore, if you're watching Fox on cable, which is true most of the time, or CBS or NBC for that matter, these rules don't apply to cable. Cable is something you invite into your house and you pay for, therefore you have a right to hear it, and the indecency does not apply to cable. So you have that problem that you have to deal with on top of everything else.
Well, do you think it's a valid argument? For an example, I might argue that when you turn on the television, you invite the public into your house. Is that an adequate sense?
Well, in FCC versus Pacifica, which I think is the real problem here, the FCC said that broadcast television and broadcast radio are such pervasive media that you can't control them, that your children can tune them in from anywhere, and therefore we can put restrictions on it. But the problem is the indecency standard is so arbitrary and so capricious, sometimes based on context, sometimes based on actual words, that the Supreme Court should probably just throw it out. And I think they can use FCC versus Fox as the vehicle by which they can trim back Pacifica versus the FCC.
I think that this shows some of the complicated nature of the First Amendment when it comes to what the current court is faced with. I'd like to thank you for joining us today, and it's been a pleasure to spend some time with you. These cases will mark a lot of the First Amendment jurisprudence for years to come. It is the most important time for our First Amendment rights when we face national security threats, campaign, election financing, student free speech rights, and the future will be largely determined by this Supreme Court.
And a special thank you to the Long Beach Community Foundation for their generous support.